Hello, good afternoon, everyone. Wow, after the performance by Tracy and Soo-young, who is now leaving goodbye for India, I'm not sure how I can follow two such wonderful speeches, but I'll try my best, and hopefully you won't be terribly bored about what's to follow. I do want to say a little bit in terms of particularly what Tracy had to say. So there's going to be a little bit of an overlap, but I think I'm going to take a slightly different twist on some of the things that Tracy was talking about, so that we can look forward a little bit in terms of the new HBR legislation. So, and one more thing I do want to say, just like Tracy, I've done the same thing. I've come up with my copy of the Act. And the reason I've done that is for the same reason that he did, is that I keep finding things in it, or wondering whether I've misunderstood things in it, or whether it can be interpreted in a different way. So you'll have to bear with us, because I think we're still learning quite a bit about what this Act is about and what the implications are. So a very brief outline of what we're going to do today, and some very important caveats I need to mention. So a quick overview, again, a slightly different twist to what Tracy did earlier, and a look at the definition, and a look at the definition in the context of some of the studies that we've been reviewing in our roundtables earlier. Again, the same thing in terms of consent, and I want to focus a little bit about the consent relating to children and for adults who lack capacity. Then some comments on the responsibilities for the three big groups, and the caveats that I want to mention. Obviously, this is a 20-minute talk. There's only so much I can cover today. So I've tried to kind of pick out interesting, hopefully, items that you'd be interested to learn about. The regulations, as already has been mentioned, have not been published, and a lot of the details will be in the regulations. So we'll have to wait for those to come out, and we'll probably get quite a bit of clarification in the regulations. And that's why I want to kind of mention the workshop, because we are going to be running workshops on the new HBR legislation. And the first one I can tell you is likely to be slated on the 18th of February. That date's not been confirmed, but I assume that all of you will be on our mailing list. So when that's confirmed, you will get details about that by email. And that's probably not going to be the only workshop we're going to be running next year. We'll probably be running at least 2, I imagine, on the legislation. So, to get started, as you know, it was passed very recently. There's a sunrise period, as just confirmed, and it regulates human biomedical research. It prohibits certain types of research. These are called restricted research, and the examples of that are here on the screen that you can see. Now, the purpose. I think it's really important to look at the purpose of the legislation, and Tracy touched on this a little bit. So during the parliamentary debates, this is what the Minister of State had to say when he was moving the bill. He said, "It's for strong ethics governance and protection for people who are subjects of such research." And then he added, "It's also a proactive measure to help ensure that Singapore maintains its reputation as a biomedical research hub of international standing." So this tells us a little bit about the rationale, the reasons behind the introduction of this law, which is basically as you see on the screen. Now, in terms of the definition, we've had a lot of conversations about the definition, and funnily enough, the PDPA has come up quite a bit, right? So the way I'm trying to remember that first bullet point, the prevention, prognostication, diagnosis, and alleviation, is using that very acronym, PDPA. Prognosis, prevention, diagnosis, and alleviation of any disease, disorder, or injury affecting humans. And then we have the provision about cosmetic kind of procedures, and then all human performance or endurance. But this is just part 1, and it's got to be read with, if you like, part 2. And this is where the research involves an intervention, which has a physical, mental, or physiological effect, and that can be temporary or permanent, or it uses individually identifiable human biological material, or you use individually identifiable health information. Now, those two terms are actually defined within the Act, and I know it's in teeny-weeny print, and I apologize for that. It's not really for you to to read, but just for you to know that these terms have been defined within the Act. So yesterday we had a consent form that went around in the first roundtable, and this was the tumor profile test, the consent form that everyone reviewed. And some of the tables, as I understand it, had a discussion about whether or not this particular study would have fallen under HBR, right? Is this HBR? Now, why would that question even arise, you might think? Okay, one of the issues that came up is that after the tumor, the tissue that had been taken out, after the tumor tissue had been removed and the test was conducted, no biological material would be left, right? So it would be destroyed from the actual test. So there is this genetic data, obviously, that you're getting from the tumor tissue, but there's no actual tumor left. So do you need to actually have tumor tissue for it to qualify as HBR? So when obviously you're taking the tumor tissue and you're conducting this test, you're also gathering a lot of personally identifiable information from the patient. So it's definitely identifiable. It falls under all of the other criteria with being an intervention to study the alleviation of a disease. So it is definitely HBR. However, for the subsequent, when they anonymize the data, the tumor profile data, and that data is shared with other researchers, the anonymized data, that arguably would fall outside of scope, because those researchers would only be getting the anonymized genetic data, whereas the original team who used the tumor tissue and they have the personally identifiable information, that becomes HBR, but subsequent research using the anonymized data would arguably fall outside HBR and therefore not be covered by the Act. So there are a couple of other exclusions, if you like, in relation to HBR, because you're probably thinking, well, what about simple survey procedures of minimal risk? Is this also HBR? So the second schedule lists a series of exclusions, and the two main ones. The first one is research on normal human physiological responses and behaviors which are not designed or intended to study psychiatric or psychological disorders, and of course the important caveat, involve no more than minimal risk to the subject. And the second one relates to measuring human intelligence, and again, not designed or intended to study mental or intellectual disability and involves no more than minimal risk. Now, here you can see there is actually, again, tiny print, sorry, I couldn't fit all these on one slide. You can look at that copy of the Act. It does actually define minimal risk in the Act, and it's the one that we've already discussed yesterday. It came up that it's not greater than that ordinarily encountered in the daily life of a sort of healthy person or during the performance of routine physical activities. Now, when we look at this definition, we looked at another study yesterday, or rather, actually no, it was today. I'm losing track of time. That was the SHARP. Today we talked about the SHARP talk study in the SHED protocol, and hopefully you remember that this was about an online study where they were going to review the discussions that were conducted with 16 to 25-year-olds who were at risk of self-harm. So the question is, would the SHARP talk study fall under an exemption where, would it fall under an exemption because there's no sort of direct physical intervention? And I think it's probably likely that it won't fall under an exemption for the reason that it is designed to study a psychiatric or psychological disorder. So that study, even though it's conducted, if you like, entirely online without a sort of real intervention as you might think of as scientists and doctors, arguably would fall under the HBR legislation. And then there are a selection of other exclusions as well, some of which we've already discussed today, for example, clinical trials, which fall under a different regime. So, and then also, I think Tracy mentioned, these are the catch-all ones. If your research involves any of these, it's automatically HBR. consent, also touched on by Tracy, but we will talk about it a little bit more as well. So this is the general rule, which shouldn't surprise us, really, in writing from the subject personally. The slight difference here, it's not just about the provision of information, it's also about it being explained. So it's got to be explained properly in order for you to get appropriate consent. And then, of course, when we think again about it being witnessed, and then there are a few exceptions that we're going to talk about. But again, earlier we talked about the sharp talk study. Right? Would you be able to get appropriate consent under the new regime for the sharp talk study? So, for example, when we look at requirement number 1 for it to be obtained in writing, if it's done online, if you click the yes button, does that satisfy the requirement that it's in writing? There's certainly an issue in relation to it being witnessed, because I think that's highly unlikely to happen unless you're doing all of this by Skype. But there's also the issue if you're doing online research, can you actually ensure that the person that you're communicating with on the other side is the person that they claim to be? So there could be even an issue of identification and knowing who that person could actually be. Now, in relation to, we just talked about that, then there's a waiver. I do want to talk a little bit about the waiver. There is a waiver of written consent. So it's where there's no more than minimal risk, as you can see, and it involves no procedures for which written consent is usually required outside the research context, and where only the record linking the subject to the HBR is the consent form, and the main risk has to do with unauthorized disclosure that's contained in that consent form. So this is the condition under which you might be able to obtain a waiver of informed consent. Now, Tracy earlier on mentioned the laundry list. Here is, for your benefit, the laundry list. Now, I have put it up there. Look, it's a lot of stuff, isn't it? I think there's 13 items on this laundry list. And I think, again, it's very important to stress that this is not some sort of formula that you apply and you can easily tick off, oh, I've done, that's on the paper, that's on the paper. I think yesterday when we reviewed the tumor profile consent form, there was a realization that there's a lot more to a consent form than literally what's actually on the surface. It's the way that you communicate information. It's the clarity by which you communicate that information. It's the concerns of the specific research that you're doing in order to address the concerns beyond the laundry list formulaic response. So we've got to be very careful in relation to looking at our consent forms. Not that that's the most important thing, obviously, when you're thinking about the research. And again, there are obviously things that may be legal, may not be ethical, and that in itself creates problems. But we have to be careful to avoid this formulaic sort of approach towards what is required, and think a little bit more carefully about how we're crafting these documents. Adults lacking capacity. So this is under Section 7. So the prerequisite is research of comparative effectiveness cannot be performed with other classes. So it has to be this class on which the research is conducted. Now there's a hierarchy for seeking consent. So the first port of call is the donee or the deputy. So the donee obviously is if you've appointed that person, right, under the Mental Capacity Act. If you've got capacity, you can make a lasting power of attorney appointing somebody to make these decisions on your behalf. But under the Mental Capacity Act, you can only do, if you've appointed a donee, you have to specifically say you want this person to make these sorts of decisions on your behalf. So you can't, it's not quite a tick box thing. It has to be a specific addition to your lasting power of attorney. But if you haven't got one of those, and if there's no deputy appointed, then it follows a hierarchy, which is, again, new for our regulations. And then we have spouse, adult child, parent, or guardian, and any other person named in the MCA. So, could there be issues, for example? Could there be a situation where spouses don't quite get on anymore? But this person may now be empowered to make decisions on your behalf in relation to research. Again, what if you are, haven't seen your adult child for 20, 30 years? Would this person now be able to make those decisions on your behalf? Then there's this whole concept about best interests in the Mental Capacity Act, which means that you're supposed to be making decisions on another person's behalf in their best interests. And one of the questions that you probably need to ask, and I think this may have been brought up in some of the BAC guidelines, is if there's no direct benefit, is consenting to the research, is that going to be in the best interests of the patient, or in this case, the donor? What about minimal risk? And does it have to be of direct benefit? Minors, another very interesting category. I have to sort of tried to kind of break it down into these pieces. So the dual consent thing, as Tracy mentioned, is very interesting. How sufficient understanding and intelligence is going to be measured is also going to be interesting. When does a child acquire sufficient understanding and intelligence? And of course, that will probably vary depending on the child. But could a parent turn around and say to you, no, my 14-year-old is very immature. I don't care what you think. You may think he has sufficient understanding and intelligence to be able to consent to this research, but I know my child better. My child definitely wouldn't be able to make a decision. What then is your duty as a doctor, or your duty as an IRB when you see a protocol with a 14, 15-year-old teenager where the dual consent provision is not being used, and you're going under the third provision here where the minor lacks sufficient understanding and intelligence to make a decision. Now, in relation to IRB duties, these are the things, these are the points in relation to minors that the IRBs will have to do, whether they're capable of giving consent, having to review the provision, or whether there's whether they've met the requirement of sufficient understanding and intelligence, and also the provisions in relation to how consent is actually taken. I'm probably running out of time, I am. Okay, waiver of consent. There is a provision for waiver of consent when it comes to minors. I don't have to read this, I'm sure you can do that. Some general provisions that could be of interest to those of you here who are from the IRB, how they're appointed and the supervision and control, that of course a member can be a member of more than one IRB. And in terms of joint collaborative research, again, the appointment of a lead IRB, which is hopefully going to encourage and promote research. In terms of ethical review and functions of duties of IRBs, these are also spelt out in section 32, and you can see these are the things that the IRB would need to have to assess. Oh, and some more. Composition and quorum. So some of this will be spelt out a bit more in the regulations, but some important things to note is that it does actually say in the Act it's a minimum number of 5, but the Minister again has stated in the parliamentary debates that there has to be at least one scientific member external to the research institution, one lay member, and the chair must be a medical practitioner. I think Tracy mentioned the appeal process. I've detailed that very briefly there. Liability. People are always very interested to know about liability. Okay, so the good news is individual members are not criminally responsible when making decisions in relation to the proposals that they review. It's the research institute that's responsible. But again, the minister did say this, that members may be subject to duties arising in general law relating to the discharge of your IRB functions. And they expect RIs to indemnify their IRB members against legal liability. So, I mean, what would these do? What would these sort of general law provisions be? Possibly negligence. But it looks as though the RI has to do something about it to protect IRB members. Supervision and control. So, yes, this is Singapore-based requirement. So, all HBR must be supervised and controlled by a Singapore-based research institute, and has appointed at least 2 people who are ordinarily resident here to be responsible for that supervision and control. Now that's quite interesting, and I kind of wonder why that was there. But I understand that there's some educational institutions in Singapore which have a base outside of Singapore. So they may, for those sorts of institutions, they may insist that there is a local-based IRB to review protocols rather than sending it to the home institute in a foreign country to conduct the review. And then here's a list of requirements of what the researcher has to ensure before they start research. Deviation. Protocol deviations. Deviations may be a criminal offense, so you have to make sure that they've been reviewed and approved or exempted. And here are the requirements about what you need to do with deviation. Again, so I've kind of highlighted just 2 points here about the proactively monitor. It raises the question about whether we are already proactively monitoring research, and if we are, if that's, what we're doing is adequate at the moment to meet the requirements in the bill. So some more of this may be spelled out in the regs, so we'll have to wait and see. The other interesting point here is about investigating, areas of concern. So some sort of investigative powers have been vested upon the Research Institute. So it depends, again, on to what extent that needs to be conducted by the research institution. And things that now have to be officially informed to the DMS in terms of reporting. Whistleblowing. Sorry, I'm going through this really quickly. So whistleblowers have their identity protected. This wasn't in the original version of the bill, but was added in the final one. So if you inform on wrongdoing, your information, your personal data may be, your identity may be protected. Employers are liable for acts of the employee in these sorts of circumstances, and this particular provision doesn't apply to the government. I thought, I'm glad you found that funny. Okay. I think this is the last slide, and I'm running out of time. A note about legacy human biomedical materials, which, the legacy thing has come up a couple of times during this conference. Now, the Act doesn't apply to legacy materials, but look at the definition of legacy materials. Removed from living or dead persons before the appointed day, and we presume the appointed day is coming up, it's not here yet. Biological material from a dead person stored for HBR before the appointed day and is non-identifiable before the appointed day, right? So in other words, does legacy mean only non-identifiable material before this date? So all of those tubes with names, IC numbers, other information may not come under the definition of legacy material. And I think with that, thank you.
Thanks, Sumi. So I'm going to open up the floor for questions to both Sumi and Tracy.
Could you go back to the slide, back to the slide on whistleblowing? So first of all, my main question is actually about the protection of their identity. But the court, not all whistleblowing circumstances involve a court. Or is this limited to the court? So for example, if there is somebody in the institution who makes an allegation of wrongdoing, and it's not clear from this what kinds of wrongdoing are involved, then there's no court involved. So that's my first question. Is there another mechanism? The problem, though, with the protection of the identity is how can there be a questioning or an inquiry that tries to ascertain what the informer did or didn't do? I guess that's taken care of in the second one. Justice cannot be done without revealing the identity. But there is a provision that if a person is accused of something, that person has a right to confront or face the accuser under certain circumstances. Not in the hallway, but in either in a court or in some duly established mechanism. So my questions are, first of all, what is the kind of wrongdoing that is envisaged here? And does the word whistleblower cover allegations of some form of scientific misconduct?
Very good questions. You can see now where we've brought our copies of the Act. Okay, so I'm looking at it now. The whistleblowing, by the way, is my term. It's not, that word doesn't actually
What words
appear.
are there in there?
Information and identity of informers not to be disclosed is the title.
Informer?
Yes, uses informer rather than whistleblower. So it says basically no information disclosed by an informer for an offence under this Act. So in other words, it only relates to offences under this Act. So other things outside of the Act would not be covered.
But the Act has so many things in it. It's got
yes.
enough there. I'm not worried about that.
Yeah, they have lots of things. So it's so these provisions in relation to protection of the identity only refers to criminal offences under this particular Act.
Are all of the offenses criminal offenses?
All of the offences.
I mean, is every violation of what's in the Act, does every violation constitute a criminal offense?
There are quite a few criminal offences in the bill, yes.
But some are not.
Yes, some are not.
Okay, yeah, so I think, I'm not sure what Ruth's specific concern is, but based on what you've said so far, first of all, it's probably saying too much to call it a whistleblowing provision, because it doesn't protect your employment status and that sort. All it does is protect your identity in criminal proceedings. Yes, it's very limited. It protects your identity in criminal proceedings where your identity may be a relevant fact, and it protects it in that procedural context, right? You also asked, is right to accuse. Well, that I believe is one of the amendments to the U.S. Constitution. That right doesn't exist in ours. So you don't have a procedural right to confront your accuser in Singapore. We don't have that particular constitution. Yes. So the emphasis, to summarize again, this is not as wide as whistleblowers probably would like it to be. It protects the identity in criminal proceedings. And the last point is, yes, not every obligation in the Act results in criminal sanctions. Certain core ones they have pinned criminal liability to, but not everything in the Act is criminal for failure to breach. But I didn't have a chance, but the whole slew of other enforcement powers that the Act has that the regulator can deploy, for example, stoppage orders until we sort out what's going on, don't continue unless you have the Act can also prohibit individuals from conducting research if there's a concern that they're not complying with the Act or its guidelines. So I think the point being that this arises basically with a concern that we want to some extent to encourage people to raise concerns about things they are seeing which it is impossible for the regulator to see, but obviously it does not go as far as a whistleblower would like. Yeah, please.
I'd just like to flag something that was brought up kind of as a footnote in this talk, but it was something relevant to what we were talking about before, which is the definition of minimal risk under the Act. And this was, so yesterday in our discussion of the opt-out consent case, that Chilean study, I think it was Ruth Macklin that brought up this question of, well, if the kids are exposed to lots of high risks in their everyday life because they're from a very dangerous neighborhood or something like that, maybe you can expose them to higher risk in the study. The definition under the Act would, at least in a lot of cases, exclude that kind of consideration. It relies on an absolute definition of minimal risk. It's the risk that a normal and healthy person, at least in some context, would be exposed to. So even if you have a particular population that is exposed to a higher risk in their everyday life, that's not the standard of everyday life you would use for the minimal risk approach. So just as another sort of case I might consider, if you're working with elite athletes, for instance, who themselves go through really grueling training on an everyday basis, even if you wanted to propose a test of a new sort of grueling training regime, maybe a new atmospheric pressure device, you would still have to go through the human, it would still be above minimal risk, probably because the activity would be more than what a normal healthy person would be exposed to in their everyday life, even if an elite athlete might be exposed to that level of risk in their everyday life. So yeah, the minimal risk standard there is different from a lot of other, well, some other international regimes in going for a more absolute definition.